Let me ask you something. Have you ever signed something under pressure? A lease? A contract? Maybe some kind of agreement? And then immediately wished you hadn't?
Oh, absolutely. There's a reason people joke that you should never sign anything after midnight or before coffee.
Right. And here's the follow-up question. Once you signed it, did you believe you could walk into a federal courthouse and ask a judge to throw the whole thing out?
I mean, I'd hope so, if the agreement violated my constitutional rights.
That's exactly what today's case turns on, because the answer might actually depend on which courthouse you walked into and when. That's basically what we're looking at today in TM versus University of Maryland Medical System Corporation.
And this one gets genuinely wild.
Welcome back to the High Court Report. Today we're covering TM versus University of Maryland Medical System Corporation, a case about when federal courthouse doors stay open and when the Rooker-Feldman doctrine slams them shut. Strange name, I know, but we'll break it all down. The Supreme Court hears oral arguments in this case on April 27th.
Quick reminder before we dive in. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Questions about this case? Reach out to us via LinkedIn at the High Court Report. All right, here's what you need to know.
So here's what the Supreme Court will answer. Whether the Rooker-Feldman doctrine can be triggered by a state court decision that remains subject to further review in state court.
Okay, that sentence sounds like it came out of a law school exam. Let's break it down. The Rooker-Feldman doctrine, what even is that?
So the Rooker-Feldman doctrine, named after two Supreme Court cases, Rooker from 1923 and Feldman from 1983, says that federal district courts can't review and reverse state court judgments. That power belongs only to the Supreme Court, not the 94 federal district courts scattered across the country.
In other words, if you lose in Maryland State Court, you can't just run across the street to federal district court and ask that judge to undo what the state court did.
Exactly. The idea. State courts handle their own affairs. Federal district courts hold original jurisdiction, meaning they hear new cases, not appeals of old ones. If you want federal review of a state court ruling, you appeal up through the state system, and if you get there, petition the Supreme Court.
And the question the court now confronts, does that rule kick in even when the state court appeal isn't done yet? Because TM's appeal of the state court judgment sat open and active when she filed her federal case. In plain English, can the federal courthouse door slam shut on you before you even finish fighting in state court?
That's it. And the answer turns out to divide the federal circuits, literally, which made it Supreme Court worthy.
Let's tell the story, because the facts here, they're genuinely something.
The timeline in this case runs about 60 days and involves 8 separate lawsuits.
8.
8. So TM, that's how the court identifies her name redacted to protect her privacy, a 35-year-old Maryland college graduate, carries a rare medical condition. She can't ingest gluten without triggering a psychotic episode. And before all of this, she managed it carefully, a low-dose antipsychotic only when she needed it, under the supervision of her own psychiatrist. She even executed a formal advance medical directive, basically a document she prepared while she had capacity saying, if I have an episode and can't make decisions for myself, here's who speaks for me and here's how I want to get treated.
Smart planning. And then in March 2023, she accidentally consumed gluten. The episode hit. Police brought her to Baltimore Washington Medical Center. She and her father both asked for voluntary admission. The hospital said no. Involuntary, based on their assessment of her cognitive impairment. And here's where things got complicated fast. The hospital decided she needed antipsychotic injections. Not the low-dose oral medication she'd managed her condition with, but a long-lasting injectable version. She refused. The hospital convened a clinical review panel, a formal process under Maryland law. The panel approved the injection twice. An administrative law judge upheld the second approval. The hospital never actually administered the injection, but the threat loomed throughout her entire 3-month confinement.
So TM and her legal team, 5 attorneys across 3 law firms, filed a series of Maryland state court actions to get relief: a habeas petition seeking her release, a judicial review petition on the medication order, emergency motions for release. They also filed a federal due process lawsuit seeking her discharge. And then a consent order entered the picture. The hospital agreed to discharge her if she agreed to certain conditions in a court-approved settlement. The conditions: get a new psychiatrist, attend an outpatient clinic, take all prescribed medications, let her parents monitor her compliance, and dismiss all pending lawsuits. Her 5 attorneys signed it. The state court entered it. The hospital discharged her on June 12, 2023.
10 days later, still before TM even filed a state court appeal of the consent order, TM retained new counsel and filed this federal lawsuit, asking the district court to declare the consent order void, claiming she signed it under duress and that it violated her constitutional rights.
And then on June 28th, TM appealed the consent order in Maryland State Court. Later, she moved to stay that state appeal while the federal case played out. The state appellate court agreed to stay it. So now you've got a federal lawsuit open, a state court appeal frozen in place, and a district court having to figure out, do I even have jurisdiction over this case?
The district court said no and invoked Rooker-Feldman sua sponte. That's a Latin phrase meaning the court raised it on its own initiative, without any party asking. The Fourth Circuit affirmed. But the Fourth Circuit acknowledged it was going against the majority of the federal circuits on the finality question.
The Supreme Court granted certiorari, agreed to take the case.
And now, the fight. TM and UMD medical system go at it over whether Rooker-Feldman should apply when the state court proceeding still had appellate review available.
TM's first argument: the Supreme Court has only ever applied Rooker-Feldman in 2 cases, the 1923 Rooker case and the 1983 Feldman case. And in both, the federal plaintiff had fully lost before the state court of last resort, before filing in federal district court. Her state court appeal, still open.
And she leans hard on Exxon Mobil Corporation versus Saudi Basic Industries Corporation, a 2005 case where the court tried to rein in an overextended Rooker-Feldman. The court said in that case that the doctrine only applies to cases involving the losing party in state court, who filed after the state proceedings ended. TM argues those words mean what they say. The state proceedings have to end first.
UMD pushes back on that. They point out that Exxon Mobil began its actual holding with the phrase, "the Rooker-Feldman doctrine we hold today," followed by a 4-part test. And that 4-part test doesn't mention finality at all. They call TM's finality requirement a stealth 5th element that the court never actually announced.
TM's second argument involves the statute that anchors the whole doctrine, 28 U.S.C. Section 1257. That statute says the Supreme Court holds jurisdiction over final judgments rendered by the highest court of a state. Her argument: if Rooker-Feldman derives from a negative inference in that statute, it can only restrict district courts from reviewing the things that statute covers, final judgments from the highest available state court. Her consent order never reached Maryland's highest court. It sat at the trial court level, pending appeal.
The hospital's response to that one? Rooker-Feldman goes deeper than Section 1257 alone. The hospital argues that federal district courts simply don't carry appellate jurisdiction over state court judgments. Full stop. Congress never granted that power, and the lack of it doesn't toggle on and off based on whether the state appellate process concluded. Think of it this way. They argue that whether you call it an appeal or call it a freestanding constitutional lawsuit, if you're asking a federal judge to declare a state court judgment void, you're invoking appellate jurisdiction that district courts don't possess.
And TM counters that what she filed isn't really an appeal at all. It's a collateral attack on a judgment, a separate proceeding, more like a habeas corpus petition, which courts have historically treated as original, not appellate, jurisdiction. Federal courts have long entertained collateral challenges to judgments without treating them as appellate review. The hospital says that analogy misses the mark because habeas targets the executive branch's detention, not the judgment itself, and Congress created habeas jurisdiction through explicit statutory text, which doesn't exist here.
The third front involves practicality and policy. TM argues that Rooker-Feldman already causes enormous confusion in the lower courts. She cites multiple federal judges, including Sixth Circuit Chief Judge Jeffrey Sutton, who called the doctrine a source of endless mischief that helps nobody. Expanding it to non-final state decisions makes the problem worse, she argues, not better. Other tools, preclusion doctrines and abstention, already handle the federalism concerns without a jurisdictional sledgehammer.
And the hospital lands a pretty sharp practical point in response. TM's rule creates a bizarre incentive. A state court loser who files in federal court one day before the state court appeal deadline expires gets federal jurisdiction. A state court loser who files one day after the appeal deadline passes doesn't. And even more strategically, a plaintiff could file in federal court, get a favorable jurisdictional ruling, and then voluntarily drop the state court appeal, manufacturing the finality that Rooker-Feldman requires. The hospital argues that jurisdictional rules should never be that gameable.
So what does this actually mean for real people?
If TM wins, and the court holds that Rooker-Feldman can't apply while state appeals remain open, anyone who gets an adverse civil judgment in state court and believes it violated their constitutional rights gains a potential path to federal district court, even while the state appeal plays out. For ordinary people, that sounds appealing. More access to federal courts, more venues to vindicate constitutional rights.
But here's the practical complication. You now run parallel proceedings, state appellate court and federal district court simultaneously adjudicating whether the same state court judgment violated your rights. Two sets of lawyers, two court systems, two potential contradictory rulings, respondents like hospitals, employers, landlords, anyone who signed a state court consent order or one at the state trial level now face duplicative litigation, and the hospital's example from this very case makes the point vividly. TM filed 8 lawsuits total arising from one hospital stay. The district court denied her preliminary injunction on the merits, noting that her 5 attorneys dismissed an earlier federal lawsuit with prejudice, behavior the court found difficult to square with a genuine duress claim.
If the hospital wins, and the court confirms that Rooker-Feldman applies regardless of whether state appeals remain open, the rule becomes cleaner and more absolute. State court losers who want federal review must exhaust state appellate options first. Then petition the Supreme Court if a federal question exists. Federal district courts stay out.
The cost: potential denial of urgent federal relief to someone like TM, who faced continued confinement and the threat of involuntary injection while waiting for state proceedings to resolve. Her lawyers argued the whole point of filing in federal court was the pressing need for immediate relief before the state appellate process concluded.
And this carries implications far beyond involuntary commitment cases, custody disputes, state court consent decrees in civil cases, property judgments. Anytime someone loses in state trial court, claims the judgment violated their constitutional rights, and wants federal court intervention. This case draws the boundary.
So what should you watch for at oral arguments?
The justices will likely press TM's team hard on the anomaly the hospital identifies. What exactly triggers Rooker-Feldman under her rule? When do state proceedings end? Courts on her side of the circuit split already developed 3-part tests with their own subcategories to figure that out. Expect the justices to ask, doesn't your finality requirement just create a new layer of jurisdictional complexity you claim to want to eliminate?
Watch for questions about the strategic behavior problem. If a plaintiff can file in federal court while a state appeal stays open, then voluntarily dismiss the state appeal after getting a favorable jurisdictional ruling, did Rooker-Feldman just become optional?
And on the hospital side, expect hard questions about the structural argument. If district courts truly lack all appellate jurisdiction over state court judgments, as the hospital argues, What does that mean for existing collateral attack doctrines? For the habeas analogy TM presses, the justices may push to understand where the hospital draws those lines.
One more thing to watch: Petitioner's backup argument. TM argues that if the court won't limit Rooker-Feldman to final state court decisions, it should overrule the doctrine entirely. The hospital calls this a Hail Mary request beyond the scope of the question the court granted certiorari to decide. Whether any justices take that invitation seriously or treat it as outside the scope of this case tells you something about where the court's appetite for doctrinal house cleaning runs in 2026.
Bottom line, time. Why does this case matter?
Because it determines how broadly the rule against federal district courts second-guessing state courts actually sweeps, and whether people urgently seeking federal constitutional relief can access it before their state court fight concludes.
For anyone who ever faces a state court civil judgment, they believe violated their federal rights. And those situations arise constantly across custody cases, civil enforcement, consent decrees. This case decides whether a federal courthouse door stands open or locked while state appeals play out. If you made it this far, share this episode with one person who thinks Supreme Court cases only matter to lawyers. This one directly touches who can walk into a federal courthouse and when.
Because it turns out, the right to knock on a federal judge's door might depend entirely on whether you finished knocking on state court doors first.
We'll cover the oral arguments and the decision as the term moves forward. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report.
And if you're the kind of person who shares podcast episodes, you've just helped explain the Rooker-Feldman doctrine to someone who had no idea it existed this morning. That counts for something. Talk to you soon.